My name is Robert Pearce, and almost every week I get a telephone call from a stockbroker wanting to clear his or her record of a false customer complaint or other inaccurate information placed on a Form U4 or a Form U5 by an employer that ultimately appears on the CRD and the BrokerCheck record that is available to the public worldwide. And today it's more important than ever to eliminate those false claims, to make sure that the information that appears on your CRD and your BrokerCheck is accurate, because employers are less willing to hire those or keep those employees with many complaints in their employ. Similarly, when a broker tries to get registered, or even while they are registered, regulators, FINRA and state regulators, can initiate actions to take away their registrations in that particular state, or by FINRA altogether in the United States. Now, the good news is that false claims filed by customers, claims that have no merit, they can be what we call expunged, removed from the CRD and the BrokerCheck. However, FINRA controls the CRD, FINRA controls the BrokerCheck, and FINRA has the rules that dictate how those false remarks or on your U4, your U5 are removed. The most onerous set of rules relates to customer complaints, and there is a policy at FINRA to discourage arbitrators from expunging customer complaints, and there are certain rules that govern the expungement of customer complaints. Rule 12805, Rule 13805, and FINRA Code of Conduct 2080 governs the expungement of customer complaints from brokers' records. Now, it's a two-step process. At first, you have to file an arbitration, and the arbitration is generally filed against the broker-dealer that placed the mark on your record, and or the customer that filed it. Sometimes these expungement proceedings take place during the course of the arbitration that the customer has filed. And when the case is dismissed, you have an expungement hearing. Other times you have to file the arbitration separately after the fact. And you have to win the arbitration. An arbitration award has to be entered in your favor, demanding that the bad mark be expunged. Now, in the course of that award and making the decision, the arbitrators have to make express findings. They have to find that the claim, the allegation, or the information is factually impossible or clearly erroneous. For example, some customers file complaints against brokers for a time period for a transaction when they weren't even employed at the firm. Those types of claims are clearly erroneous. Similarly, the arbitrators can make a finding that you were not involved in the sales practice violation or alleged misconduct. You may have had a partner that dealt with the particular customer, and the partner was responsible for the misconduct that's alleged on your CRD. And if you are found not to be involved, you can get that expunged with that finding. Also, arbitrators can enter an order of expungement when they find that the claim, the allegation, or the information in the customer complaint is false. In other words, arbitrators can decide the evidence in an expungement proceeding and conclude that it was false. If they conclude it was false, they can order an expungement. Now, it's not over at that point. You get an arbitration award. What do you have to do next to get rid of a customer complaint? Well, you have to file a confirmation proceeding in a court. And FINRA is a party to that unless they waive their right to be a party under the FINRA rules. And generally they do waive it, but you have to make an application to FINRA asking them to waive their right to participate in the court confirmation of that arbitration award. And if they do, it's generally a very easy process to get that customer complaint expunged. Now, on the other hand, where the broker-dealer files a false and defamatory claim on your record. It's not a customer complaint. It's usually on the Form U5. And even in those states like New York and California, which you may have heard me say on earlier videos, where those statements are absolutely privileged, you can't sue them for defamation, you can still get the false and defamatory claim expunged. You file a complaint against that broker-dealer, and you may not be able to sue for defamation, but you sue for expungement. And if the arbitrators agree with you that that's false and defamatory, they can order expungement. And you don't have to go through that second process like you had to do with the customer complaints. You go directly to FINRA, you show them the arbitration award, this was false and defamatory, and FINRA takes it off your record. So that's what you need to do. You very rarely have I met a customer, a broker, that can do this on their own. You're going to need to hire a FINRA arbitration lawyer that's knowledgeable of expungement proceedings, the policies, the procedures at FINRA, and more importantly, in the case of defamatory statements, how to prosecute a defamation claim. And we're here to help you if you need us.